Hello, my name is Gabriella Cruz, and I'm a director at the Global Digital Asset and Cryptocurrency Association. Today, I'm going to be introducing you to our emerging arbitration system, and we'll be discussing this with my friend and colleague Matthew Lyle, who also happens to be chairman of the board of the Global DCA. Matthew?
So I am the general counsel of Drawbridge Lending, which is a fairly new firm concentrated in the institutional structured product space that uses cryptocurrency derivatives in a number of useful and innovative ways. We got involved in this initiative because from our perspective, doing business in the cryptocurrency space, it can be a little bit uncertain from a regulatory and a legal standpoint. For example, a very easy example is that we use cryptocurrency as collateral to secure lending lines. And in order to use collateral, you want to be sure that the liens on that collateral are good from the standpoint of if your debtor goes into bankruptcy, that a bankruptcy court will recognize that that lien is a first lien and give you priority over that asset. Right now, I can't tell you that it's 100% certain that that would be the outcome in a particular bankruptcy with respect to digital assets or cryptocurrency. So we see a business purpose behind the Global DCA, and that's why we've gotten behind it in a big way. Now, in terms of arbitration, which is, I believe, what we want to talk about right now, arbitration is an interesting, it's an interesting tool that firms or commercial enterprises can use, especially. Why? Well, because we all are pretty aware that to sue another firm, bring a court case, go to trial, can take years, can cost a lot of money and legal fees and so forth. And then the outcomes are not assured. You just can't, with any really good certainty, know what the outcome is going to be. With an arbitration system, however, it's designed typically to reduce the time that it takes to get to an outcome. There is also less cost and expense and burden with respect to these, because they're more streamlined affairs, and they essentially eschew or avoid the trappings of a long litigation case.
Excellent. Well, that sounds really exciting, and like it might be something that could really help a lot of different firms. One of the thoughts that at least comes to me is how this might be able to be used by, not just trading firms or those that are involved in financial services, but can you talk a little bit about how this might be something that can be used, especially for those that are startups or in the technology space? What benefits can arbitration offer to them?
Certainly, and I think that that's a great question. So arbitration is something, like I said, is more efficient and less costly typically than a court case. The way it works is as follows. In order for the arbitration process to be triggered, there typically is a contract or an agreement between two parties, which is in writing, and it has a written provision in it saying that any dispute will be arbitrated rather than litigated in a court of law. So that's where you start, is a contractual provision that both parties, that clearly signifies that both parties have agreed to arbitration. That's important because not only does the arbitration system want to see that before they will agree to arbitrate the case, but if you want to enforce your judgment, a court of law is going to look at whether or not that was a clear agreement between the parties before they will get behind an actual arbitration decision or look to unwind it. So that's the most important thing, is to get an agreement between the parties up front that they're going to arbitrate any dispute.
I had a question. One of the things that you kind of talked about was the idea that this has legal standing. Can you talk a little bit just about what the precedent is, or if there are any, legal backing that can really help to enforce arbitration?
Yeah, sure. So there is a federal law that has been around for a long time called the Federal Arbitration Act. And that act is a fairly narrowly drawn, short act that essentially enforces commercial arbitration disputes on the basis that both parties have agreed to arbitrate that dispute.
Okay.
So what does that mean? It means that both parties have agreed that they will not submit a dispute to a court of law, a public forum.
Yeah.
Instead, that they will submit that dispute to a private arbitration system. We have heard of if you've read contracts in the past, people have heard of the major arbitration systems providers like the American Arbitration Association, or AAA, AAA is what people call it, or
Yeah.
JAMS. Those are two that you see very frequently in contracts that are used. Those are commercially offered services. But the Global DCA has the ambition to start its own arbitration system. And this arbitration system is based upon a well-worn model that was first introduced by an association called the National Grain and Feed Association. This is a system that has been in place since the 1890s.
Yeah.
It's well worn, and it's available for the grain merchandising industry, which is the industry that you may know through the brand names like Cargill and Bunge and Archer Daniels Midland.
Yeah.
Those are the firms that use this system if they have a dispute with another contract participant. And over time, those arbitration decisions have been challenged in federal courts from time to time, especially by parties who are unhappy with the results. And in every case, the federal courts of law has upheld that system. And so it's important, to emphasize that these are not, cases that can, willy-nilly be overturned in a court of law. Once you agree to do this, once you agree to arbitrate your dispute, then you have to arbitrate that dispute and you have to abide by the panel's decision. Now, why would you want to submit that dispute to that kind of a system? Well, I mentioned earlier, it's cheaper. It's typically can be quicker, less expensive. But the other thing that is really kind of a chief factor here to look at is that typically the arbitration panels that hear the case and decide the case, they are chosen from a body or a group of people who have demonstrated expertise in this particular area of the marketplace. And so it's not like you are in front of 12 jurors who have never heard about what you do. You are in front of a panel of 3 with people who have broad expertise in the marketplace, and they don't have any sort of axe to grind. They're independent. They have no bias or conflict in the case. So, and they will listen to the case and they will talk amongst themselves, and then a majority vote, at least 2 of the arbitrators have to vote to side with one party or the other. And then, I should also add that those decisions are going to be written and published. And so, people who are not part of the case will be on notice, with the publication of those decisions, that in a specific factual pattern, this is how the arbitration panel held. And not that there's binding precedent, but it just gives people an idea and perhaps some guidance that they can take away to see how a typical panel would rule on a particular set of facts.
That's really interesting. I think, you know, obviously the ability to access expertise, especially when you're talking about, you know, looking at and assessing code to determine, you know, what the appropriate outcome and application would be in an arbitration case. I can see how that would be extremely important to the digital asset and cryptocurrency industry. Um, can you also talk a little bit? I know the Global DCA intends to and has already attracted a lot of interest abroad. Can you talk a bit about, you know, how can arbitration process or the arbitration process that you're envisioning within the Global DCA, how can it be used by firms that are domiciled outside of the US? What application would it have and how could they participate and take advantage of the benefits really?
Sure, sure. Okay, so, and you had asked me before, so let me just take one step back and talk about accessing the system.
Okay.
So first and foremost, this system will be available to anybody that has indicated in a contract that they would like to arbitrate any dispute with the other party with the Global DCA.
Yeah.
And so that's the first thing. You do not actually have to be a member of the Global DCA to access our system, actually. There will, of course, be a less expensive charge to use a system if you are a member,
Yeah.
but you don't have to be a member. So that means that even a member who wants to do business with a non-member can put this provision in their contract, and then that non-member will be bound to have to arbitrate that dispute in that forum, in our forum. And so that's the first thing. And then the second thing is that there's going to be a set of rules that governs this system, the arbitration rules. And those arbitration rules will dictate how those cases are filed.
Yes.
Typically, generally, they're filed with the organization. They will have an administrator who's set up to receive these cases. And the cases are normally just on what they call the pleadings, which means that you just essentially file a complaint, submit any written evidence that you have, like a copy of the contract and, you know, trade confirms and emails and communications and so forth. The administrator will then take that and then serve the case on the other party. The other party will have a certain amount of time to respond to that. And then there is another set of back and forth where, you know, okay, now the original plaintiff looks at the response and can respond to that. And then the defendant will look at, you know, that, you know, response to the response and submit a final. Yeah. And based upon those written arguments, all of that will be submitted to a panel of 3 arbitrators who are chosen by the administrator at random, but they have to be unbiased and independent. Those arbitrators will, amongst themselves, decide the case and then issue a written opinion. There will be a mechanism by which a party can request an oral hearing in front of the arbitration panel. But that's usually a cost prohibitive thing to do because you have to get people in the same location, yeah. And you know, rent a room and yeah. A court reporter and so forth. So that can be a fairly expensive thing. So at the end of the day, these decisions are made and then they're published. And then a party that loses will have the right to appeal if they want, and that appeal will go to a panel of 5 appeals arbitrators, and then they will render a final decision. You had asked about enforcement. At that point, you know, if typically a party wants to try and undo or unwind the decision, they will try and take it to a court. But like I said before, the Federal Arbitration Act will, you know, usually enforce those decisions if the processes in place have been observed, and there's no irregularities. There's, things like, there's obvious bias or conflict on the panel or things like that can uh, decision, but what the Global DCA has in mind is establishing a system, in terms of integrity and trust, and we will steer away from any potential conflicts and install panels that have zero conflicts. So then you asked about a foreign company accessing the system. Let's just say this foreign company comes from Nigeria.
Okay.
Nigeria has a dispute with let's just say it's a Belarusian firm. And they could, if they had a written contract that indicated that they were going to arbitrate all their disputes with our organization, we would then be able to take that arbitration and conduct it, administer it, set the panel and make a decision.
Yeah.
It will run like any other arbitration would, whether they're in the United States or not. The key with these is usually people who are from outside the United States. They wonder whether they can get a decision enforced against their counterparty. So let's just say this Nigerian plaintiff wins the case against this Belarusian defendant. So the way you would go about enforcing this decision and trying to get the other party to pay if they refuse is as follows. You would have to go to a Belarusian court and ask that court to enter a decision in favor of the plaintiff. At that time, the defendant would be given notice. They could appear. They would probably argue that the case, should never have been brought because it was an improper form. It should have been brought in Belarus.
Yeah.
And it's hard to control that situation where, what is that Belarusian court going to do? Are they going to recognize the Global DCA?
Yeah.
We don't know that. All right. And so, but what we do know is this, that that decision will be posted on the website of our organization, and it will be publicly available. And if there is a judgment that has been defaulted upon, that default will be known publicly.
Yeah.
And so there will be, a bit of a taint against the defendant if they don't pay. They will be a little bit of an outlaw, and other people will be on notice not to do business with them.
Yeah.
And so this is how it's intended to work. It's not a perfect system. One of the reasons, or probably the primary reasons why the Global DCA decided to adopt a system like this is because we don't have any congressional mandate like FINRA or the NFA has in order to enforce our rules. So absent that, we feel like this is one way that we're going to be able to enforce our rules is through an industry consensus-driven organization that has this system in place that will be run fairly and with integrity and will be run transparently.
Yeah. Well, that sounds excellent. Thank you so much for explaining that, because at least from my side, and I'm sure for our viewers out there as well, this idea that, what happens if you're talking about two foreign entities, how would you go about, seeking enforcement, and then that big scenario of what if you can't, get restitution. So I really like the idea of making some of this publicly available and having that ability to share that information with the broader market. I think from my end, that's about all the questions I've had. You've done an excellent job, and I really thank you for taking the time to, share what you know about the arbitration system. And I would just encourage anyone out there that has any further questions, feel free to like, comment, share. We're happy to address your questions as part of the comments to this video. Thank you very much, and
My
I'll see
pleasure.
you again.